Hello and welcome back to National IAS Academy. My name is Rajshekhar. Dear friends, welcome back to yet another class by National IAS Academy. Like previous classes, in this class too, I shall be discussing next and most important topics from the UPSC preliminary examination perspective. Alright, so these are the topics about which we are going to be discussing today in this class. First one is the right to be forgotten. What is it? Forget, forgotten, forgetting something. It's a natural human tendency. But since the internet era is here, it's not so easy, or in fact it is nearly impossible or 100% difficult for the internet to forget something. So that's the reason various privacy issues or issues related to data privacy have been raised in the recent past. The context was simple. Let me give you a context. Suppose imagine I was a very bad person or mischievous person few years ago, let's say 5 years ago. So during that phase, I accidentally ended up beating some person. That was somehow captured by a media agency or news agency or some other private person. So what happened? The captured video was uploaded onto the YouTube. 5 years down the lane, I have changed a lot. I regret that. But the internet does not want to remove that content, or those people who are new to the internet, or those who are seeing me for the first time, even after 5 years, even after I have changed, they still associate the present me with the older past of mine. So that's the reason recently few petitions were filed in the Supreme Court asking the right to be forgotten to be made into a fundamental right. So somehow Supreme Court had engaged the central government to work on this, and central government has said that it is a part of the right to privacy. The central government has indicated that the right to be forgotten is an integral part of right to privacy under which article? Under Article 21 of the Indian Constitution, and it comprises the right to be forgotten and the right to be left alone. Alright, so this was said by the Supreme Court, and the center has said yes to this particular judgment. The Union government has notified the Delhi High Court that the right to privacy, which is a subset of international legal notion of the right to be forgotten, is slowly developing in India. But please remember, this right to be forgotten has specifically been mentioned in various countries, including the European countries. So the time has now come for India to openly acknowledge this particular fact. Recently, few celebrities had approached the Supreme Court regarding this particular right. So the center has said, and even the Supreme Court has said, that right to be forgotten and the right to be left alone form part of the right to privacy, which is the basic fundamental right under Article 21 of the Indian Constitution. Alright. So basically, in simple terms, the right to be forgotten means the right to have one's personal information removed from publicly available sources such as various social media platforms such as Facebook, Instagram, Twitter, YouTube, etc., such as search engines and online directories on certain grounds. Who will determine the certain grounds? It's definitely the central government. Alright. So this might include videos, photographs, identifying info, or some documents too. So here are the arguments in favor of the right to be forgotten and against the right to be forgotten. Briefly, if I may say, various arguments against the right to be forgotten include: first one is, it becomes particularly hectic or even an impossible task for the government to identify the platforms where such data have been posted. So internet is a huge thing. It becomes next to impossible for the government to identify such places. Excuse. All right. So this is the first thing. Second thing, slowly it might lead into something called as censorship, which was opposed by the Indians itself during when? During the British era. So these two are the biggest concerns. We'll have to see how the central government works in this regard. All right. Next is about Article 145. The context is pretty simple, I'll tell you. But from the examination point of view, you should remember what is Article 145 and what is it related to. That's it. So the context was recently the Supreme Court's Constitution bench has unanimously ruled that regardless of the number of judges making up the majority on the bigger bench, the decision of the larger bench will take precedence over the smaller bench. So this was set by the Supreme Court as per Article 145. What is Article 145 of the Indian Constitution? See, Indian Constitution has ensured the independence of full independence of the Supreme Court of India. In that regard, under Article 145, the Constitution of India has delegated powers to the Supreme Court of India with respect to making various rules or procedures or bylaws related to the functioning of the Supreme Court. Functioning of the Supreme Court and various matters associated with its functioning. So such power has been delegated to the Supreme Court by the Constitution of India under the Article 145 of the Indian Constitution, and in that regard Supreme Court has recently observed that the decisions made by the larger bench shall always prevail over the decision made by the smaller benches. Alright, so what are the positive impact of this decision? This ensures stability and consistency because it aims to make sure that the court's judgments are both stable as well as consistent. It becomes stable because the larger bench has upheld the validity over the issue concerning with the smaller benches. So this automatically ensures stability and there is also consistency. This will also leave a space for the Supreme Court to correct its own decisions. It's not true that the Supreme Court will always be true. Supreme Court means in simple terms, Supreme Court is made up of various judges or various benches. It might be two judge bench or three judge bench. So it will leave a significant space for the Supreme Court to correct its own decisions. Also, a stronger bench is more likely to make the right choice. Right? So please remember, majority of the cases before the Supreme Court are heard and decided by a bench of two judges, and we call it as a division bench. And if the bench consists of three judges, then we call it as a full judge bench of the Supreme Court of India. Bench of equal strength cannot overrule or reconsider a decision of a coordinate bench. It can at best doubt the correctness of a decision, which means, suppose imagine there are various petitions filed with respect to the Aadhaar bill in the Supreme Court of India. Let us suppose that firstly this particular case was heard by a Supreme Court bench consisting of three judges, and it has given its verdict. So after this bench has given its verdict, this cannot be challenged or overruled by another bench consisting of same number of judges, that is three judges. For this to happen, the bench should be larger than 3. It might be 5, 7 or even 11. Right? Okay. So the larger benches examine the question or correctness of the decision, and the majority opinion expressed by them becomes the verdict, which is binding on the lower benches. Whenever there is a doubt or a conflict between decisions of co-equal benches, it is referred to whom? This Chief Justice of India, right? Where larger benches are constituted. All right. Next one is delegated legislation. What is it? Let us imagine I'm running a company. It is a product-based company, so I'll have to supply the product, ensure its authenticity, and also provide services. If I'm handling the company as one-man army, I'll have to do the job of salesman. I'll have to do the job of receptionist. I'll also have to file GST, look into finance-related matters, and at last, in the end, I'll also work like a service guy. So it becomes impossible, right? So the company will not grow. As a result, what I do, I delegate my work. So since the company is earning profits, I keep aside a larger chunk of that profit in running the company and hiring new people. And I am asking those people to work on behalf of me as a receptionist, for receptionist one person, for servicing one person, and for finance related matters one person. So what I'm actually doing, I'm trying to delegate the work. So this is called as the delegation of work. Like that, even the Parliament of India delegated few works in the form of preparing or making bylaws or few small legislations related to the note ban or demonetization is the correct legal word. So few of the tasks of Government of India were delegated to lower authorities. It might include making of bylaws or preparing a statute legislation, etc. So this was challenged by various organizations in the Supreme Court. The Supreme Court, however, supported the legitimacy of the delegated legislation in its finding on the central government's decision to demonetize notes. However, there was one judge who dissented, and he expressed his opinion, and he said that an excessive delegation of power is arbitrary. This is obviously concerning. Whenever too much of a power is delegated, it becomes arbitrary, and it is not good for this society, especially for a democracy. As a result, there have to be few limitations on the utilization of this particular power, that is delegated legislation. So, what was the issue? See, as per the Reserve Bank of India Act of 1934, it was the responsibility of Parliament to, go for demonetization or any decision with respect to declaring a currency as legal tender. This is the correct word. Any decision or any responsibility with respect to declaring a currency as legal tender is vested with the Parliament of India, and Parliament of India had delegated this power to the central government. Further, during the note ban times or during the demonetization time, central government delegated these power to other authorities, other legal authorities, because they were unable to handle every facet of the governance system on their own. So, as a result, statutes known as delegated legislations were mentioned in this context. Here, delegation of responsibility was with respect to making of or preparing of regulations or bylaws or rules issued by local authorities that only apply in their jurisdiction under the laws. So, this was the whole context about delegated legislation. Please know the basic definition or basic meaning of delegated legislation. What does delegating a legislation mean? Why was it in use? In which context has it appeared? This is more than sufficient. Next, we have creation and abolition of district. So, who has the responsibility or power to create a new district in the entire country? It is the state governments. A particular state government can create a new district or abolish new district as per the law. So, the state governments have the authority to establish new districts or change existing districts or even abolish the existing districts. Right? So, in this context, the central government or the parliament does not have any power. So, it is the sole responsibility of that concerned state government. Likewise, recently a few states have increased the number of districts. That is, first one is Arunachal Pradesh has 25 districts now. Earlier there were 22. Manipur has added 7 new districts. Next, Telangana has 21 districts. Next, Tamil Nadu now has 35 districts. Next, what is the procedure for amending the 7th schedule of the Indian Constitution? What is 7th schedule of the Indian Constitution related to? It is related to division of powers between whom? Between the center and the states. It consists of 3 lists: union list, state list, and concurrent list. Those subjects under the union list, they are the sole authority or sole domain of the central government. Only central government or the parliament can legislate over the subjects mentioned in the union list. And with respect to those subjects which are mentioned under the state list, it becomes the responsibility of state governments to make legislations with respect to the state list. Concurrent list, it becomes or it is equally applicable to both the central government as well as state government, which means both the central government as well as state governments have equal responsibilities or equal powers regarding or concerned with the concurrent list or the subject mentioned in the concurrent list. Presently, we have 59 subjects in the state list. Earlier, there were 66 items. And what about the amendments? Whenever a particular provision with respect to the seventh schedule has to be amended, then the procedure is that a special majority of parliament is needed and a simple majority approval by half of the state legislatures, which means more than 50% of state legislatures in India should say yes to particular constitutional amendment. It might be based on the simple majority, but for the central or the parliament, it should be a special majority. Both these combined together can make an amendment to the seventh schedule of the Indian Constitution. You might all know that under Article 368 of the Indian Constitution, the Constitution can be amended in three ways. One is simple majority, the other one is special majority, third one is this thing, that is a special majority of the parliament and simple majority approval of half of the state legislatures. Right. Next, 25 years of Indo-Naga ceasefire was recently observed. The ceasefire agreements which ceased to exist was once again signed on April 19, 2022. So the various institutions were involved in this. But the basic context that you need to remember is this Naga issue, or Nagaland, you can say. Nagaland is a demand for a separate state by these people, that is Naga people, who are staying in various parts of the Nagaland, Manipur, and other some northeastern states. They are demanding for Nagalim or Greater Nagaland. It is called as Nagalim, which will include few parts of Assam, Arunachal Pradesh, Nagaland, and Manipur. Together, they want a new state called as Greater Nagalim. So this demand first appeared in the year 1918 when Naga Club was formed. Seeds of Naga nationalism was sown. Later in the year 1946, Naga National Council was set up under the leadership of A.Z. Fizo. Later in the year 1947, that too on August 14, just one day before India got its independence, NNC declared its independence. That is, Naga National Council declared its independence. Right. So then again, a few other events happened there, eventually leading to 1955, where NNC began armed insurgency, and following this, Delhi imposed, that is the central government imposed, Assam Disturbed Areas Act, and in the year 1958, AFSPA came into force, that is Armed Forces Special Provisions Act. Then in the year 1963, Nagaland was born. Then again 1964, Naga Peace Mission created. Then in the year 1975, Shillong Accord was signed. It called for unconditional ceasefire, termed as a complete sellout. Next, in the year 1980, out of NNC, National Socialist Council of Nagalim was formed. Later, this was split into NSCN-K and NSCN-IM. And in the year 1997, NSCN-IM signed a ceasefire with the government of India. Then again in the year 2001, NSCN-K signed another ceasefire. However, in the month of March 2015, the ceasefire signed by NSCN breaks down. So after that, a lot of mismanagement happened in this particular area. People were not ready to pay any heed to the demands by the central government, and somehow the talks are still going on. The issue hasn't been resolved yet. The issue is still going on. The government has appointed a committee to look into this particular matter, that is Greater Nagalim matter, and it is hoped that in 1 or 2 years the issue shall be completely resolved. All right. Next, there is an article related to the powers of tribunal versus high courts. How are the powers of tribunals different from high courts? So the context was the National Green Tribunals Act, which was constituted in the year 2010. It is a statutory body. So the act's provisions had been contested by the Madhya Pradesh High Court Advocates Bar Association. They said that no matter what, the decisions of high courts or in general courts shall prevail over the decisions of tribunals. So it is with respect to the section 3 of the NGT Act, which says the central government has not been given excessive power. So section 3 of the NGT Act, that is National Green Tribunal Act, granted the central the power to establish the NGT. Therefore, it is not required to place NGT benches in every state, and that they can be placed according to the needs. Right. So as a result, they say the National Green Tribunals Authority under sections 14 and 22 of the NGT Act does not exclude High Court's authority under Article 226 and 227 of the Indian Constitution. So the decisions of the High Courts shall prevail. Next is with respect to appointment of judges. Two constitutional articles you should remember with respect to the appointment of judges. That is Article 124 Clause 2 and Article 217. Alright, sorry, Article 217 talks about the appointment of High Court judges, whereas Article 124 Clause 2 talks about the appointment of Supreme Court judges. So, why was it in news? The Supreme Court Collegium, which was which came into being, or rather it is a practice which came into being following the three judges cases. So this system has recently come under fire from the Union Minister of Law and Justice. Why? For judges only recommending those the names of those judges that they know for appointments or promotions, rather than picking up the best candidates. So this issue has been going on for eternity now. Previously, NJEC bill was passed, which constituted National Judicial Appointments Commission. However, the Supreme Court struck down this particular commission and said that this ultraviolates the constitution, ultraviolates with the provisions of the Indian Constitution, or this is against the spirit of the Indian Constitution. As a result, we cannot approve this particular setup. So it was removed. Now once again, the Supreme Court Collegium, consisting of Chief Justice of India and 4 senior-most judges, recommends the names for Supreme Courts or High Courts, or even to the position of Chief Justice of High Court. These names are suggested by the Supreme Court Collegium, and these names are sent to the Ministry of Law and Justice for approval. They can send it back only once. However, even when no changes are made by the Supreme Court Collegium, the central government has to say yes or accept these names. So this is the controversy related to the appointment of judges. The controversy is that it has recently been alleged that the Supreme Court Collegium is recommending only those names that are known to them, rather than based on the talent or the experience or the merit. Right? So instead of being established by a law passed by Parliament or a clause in the Constitution of India, the system for appointing and transferring judges, that is Supreme Court Collegium, has developed as a result of Supreme Court decisions. This was evolved in 1980s and 1990s. Right. So this is NJAC, National Judicial Appointments Commission. It was passed. The bill was passed in the year 2014. It was a body created to end the 2-decade-old Supreme Court Collegium system of judges appointing judges. Then it used to consist of 6 people: CJI, 2 senior-most Supreme Court judges, Law Minister, and 2 eminent persons. The Supreme Court of India had issues with respect to the inclusion of Law Minister and other 2 eminent persons in the procedure to appoint the judges. Next, the critics said that judges in NJSC will need support of others to push a name through. So they fear judicial independence being compromised, and as a result, this was struck down by the Supreme Court of India. And what about the collegium system? Collegium system is based on 3 judges case. Under it, appointment of judges are made by Chief Justice of India and 4 senior-most Supreme Court judges. It has no constitutional banking, or it has no legal banking. Constitution of India's Article 124 says that appointments to be made by President in consultation with judges as President may deem necessary. Critics say that it is a closed door system which lacks transparency. As a result, NJEC was brought in. Right. Next, Prisons Act. During the recently held DGP's and IGP's meeting, the Prime Minister of India highlighted the plight that are being faced by under trials in India, and also the overcrowding of prisons in India. As per the record by NCRB, top 10 overcrowded prisons in India include Chhattisgarh, Delhi, Meghalaya, UP, and MP. These are the top 5 overcrowded prisons in India, and these overcrowding is because of the under trials. Who are under trials? Under trials are those who are awaiting their trial or whose trials were still ongoing and who have not been convicted. Right. So, and some of the data related to the number of legal aid lawyers was also revealed. In West Bengal, it is 27, in Maharashtra, it is 84, and in Haryana, it is 474. Right. So, Section 436A was highlighted. Section 436A of the CRPC, that is Criminal Procedure Code, was highlighted. It is related to the under trials, and it says, where an under trial has been detained for a period equal to half of the maximum sentence specified for the offence for which he or she is charged, they are eligible for the release on a personal bond with or without sureties. Right. Next was about DLSA meet, that is All India District Legal Services Authorities meet. It was recently held. It was held in the month of July 2022 in Delhi, and the Prime Minister of India, Shri Modi, addressed the meeting. From this particular news article, we need to understand about the National Legal Services Authority, also Legal Services Authority Act, and various authorities that have been constituted at various levels. Firstly, at the national level, we have National Legal Services Authority, which was established in the year 1995 under the Legal Services Authorities Act of 1987. This has been mandated, or this was necessitated because of one particular article of the Indian Constitution, that is Article 39A of the Indian Constitution, which is under which is under the Directive Principles of State Policy. So, as per this Act, various authorities have been established. At the national level, we have National Legal Services Authority. At state levels, we have State Legal Services Authority, and at district level, taluka level, we too have we have the legal services authorities. Their main objective is to help the poor women or pregnant women or those who are in need of legal services for free of cost. Right. So under this, Disha scheme has been started. Disha includes 4 other sub-schemes: Telelaw, Nyaya Bandhu, Nyaya Mitra, and legal literacy and legal awareness. Please go through these sub-schemes once. So this was all about today's class. I hope today's class has been helpful. I'll be sharing the I'll be sharing the link of this particular PDF in the description box below. Please download and do not forget to revise. So take care. See you in the next class. Thank you. Bye bye.